In response, Congress passed the Agricultural Credit Act of 1987. The statute required federal lenders, such as the Farm Service Agency, to make efforts to modify farm loans to avoid losses and to restructure distressed loans of farmers if the cost of restructuring would be less than the cost of foreclosure and the delinquency was due to circumstances beyond the control of the borrower. The statute also allowed states to certify agricultural mediation programs to assist in that consideration process and authorized the USDA to provide matching grants to these programs. The statute also authorized the Secretary of Agriculture to help states develop certified mediation programs under the USDA. Currently, there are 43. State law in Iowa, South Dakota, and Minnesota make the mediation process mandatory for some agricultural loans. Western Carolina University has programs for Virginia and North Carolina. It's one of 7 universities in which programs are located. Cases can also be mediated where the FSA will not make a loan or declines to make a loan. So what is mediation? Mediation is a process by which a third party assists the disputants in arriving at a mutually agreeable result. The third party, the mediator, is completely neutral, having no interest in the dispute. The mediator does not provide legal advice and does not dictate the result. The Virginia Agricultural Mediation Program began its association with Western Carolina University in 2013. It's funded by the U.S. Department of Agriculture with additional support from Western Carolina University. It provides free mediation services for a variety of agricultural disputes. The agricultural mediation programs have expanded since the 1987 legislation. Initially, regulations provided mediation for producers, their creditors, and others directly affected by USDA actions, typically adverse decision letters. Subsequent regulations, however, authorized the use of mediation in disputes over agricultural loans and with creditors other than the Farm Service. Also, authorization for disputes with other agencies were enacted, such as the FSA conservation programs, rural development, the National Forest Service, the National Resource Conservation Services, and the Risk Management Agency. Another example of disputes covered by the statute, the Federal Crop Insurance Corporation can insure or provide reinsurance for agricultural commodities grown in the U.S. if the losses of the insured commodity are due to drought, flood, or other natural disaster, with some exclusions due to negligence or unsound farming practices. If a dispute arose concerning coverage, that's another example of a dispute that the agricultural mediation programs can mediate. The 2018 Farm Bill had a profound effect on state agricultural mediation programs. It was passed by Congress, as it is every 5 years, and it governs an array of agricultural and food issues. It expanded coverage of agricultural mediation programs, the types of disputes that could be mediated, and also expanded funding for the program from $3.9 million to $5.54 million, which is about a 40% increase in funding to support these agricultural mediation programs across the country. One type of dispute that was added was the National Organic Program. The National Organic Program determines national standards for the production, handling, accreditation, and labeling of organically produced products. Producers have to follow practices specified in the regulations in order to be able to market their products as being organic. For example, improving the soil quality, opting for naturally sourced fertilizers, using crop rotation methods, and relying on natural insect predators instead of synthetic chemical fertilizers or pesticides containing synthetic ingredients. Becoming certified can be time-consuming and costly, but financially rewarding. And losing that organic certification for non-compliance can be financially damaging. Disputes could involve compliance under the USDA organic regulations, as well as continued certification. Mediated agreements could require additional inspections, for example, or testing at the operator's expense. The 2018 Farm Bill also allows mediation programs to mediate disputes concerning leases of land or equipment. About 39% of the farm acreage in the U.S. is rented, often because of liquidity concerns and affordability. Leasing equipment can also make sense for economic reasons, such as to improve the debt-to-asset ratio or to provide an ordinary necessary business expense for tax purposes. So disputes can arise regarding delinquency in payment, the use of the land, capital improvements, subleasing, repairs and maintenance of equipment, insurance coverage and payments, or compliance with existing laws and regulations, including tax obligations. Those disputes can now be mediated. Additionally, the Farm Bill permits mediation of producer-neighbor disputes now. Examples of such disputes can include problems about odor, like the stench of manure, pigs, noise, roaring machinery, the use of pesticides, for example, mists of pesticides in the air, traffic associated with agricultural tourism, boundary disputes, as well as view obstruction or eyesores. These types of neighbor disputes can also be mediated. For example, right-to-farm laws in every state protect qualifying farmers and ranchers from nuisance lawsuits that attempt to stop ongoing operations. These laws carve some protection for farming operations out of traditional nuisance law, which otherwise might favor non-agricultural uses and considerations. Many of these statutes were passed by state legislatures concerned about the loss of productive farmland to non-agricultural uses. So with increasing urban-suburban encroachment, more disputes could arise concerning how these laws should apply in any given situation, with mediation being a viable option for resolution. Additionally, the 2018 Farm Bill allowed agricultural mediation programs to engage in farm succession planning. So what is farm succession planning? Well, a farm succession plan is the process of passing on the ownership of a farm to another person, and it's usually a family member. In 2016, it was estimated that over 70% of U.S. farms would be transitioning in the next 15 years. If farmers want the business to continue, a plan is necessary for subsequent operations. Farm transition planning can be very complicated. Multiple considerations must be accounted for, like taxes, inheritance issues. Who will assume responsibility for the farm? What about staffing and human resource issues? Retirement planning for the owner who plans to retire and future generations who plan to operate the farm. Operational issues. Will the farm continue to operate in the same manner, raise the same crops, etc.? And ownership. Will the heirs want to work on the farm or engage in other agricultural production? Debt needs to be considered, lease terms if equipment or other items are leased, as well as insurance. A few preliminary decisions have to be made. What does the producer want? What is the producer's vision for the future? Vision for the family, the land and the business, the legacy, heirloom, or career opportunity? All those considerations come into play. What does the producer have? Resources, liquid and not so liquid. Family resources, status and abilities, current documents, community resources? And then finally, what does the producer need? Financial resources, an asset transfer plan, an estate plan, the consideration of a business organization, and the disposition of the business, transfer or liquidation. Now, how can mediators help? Well, mediators can work with the owner, the producer, and family members to examine options and determine the best solution for having the farm survive. They can help to resolve long-term standing conflict that may impact these types of decisions. They can facilitate communications between family members with diverse opinions and diverse visions for the operation. They can examine the viability of the farming operation when considering accumulated debt. They can determine an equitable succession plan if the operation is to be ongoing. And finally, they can discuss family partition issues in co-tenancies if, in fact, the enterprise should cease operations. Certainly, the pandemic had an impact on agriculture in general and on our mediation program as well. Today, we can engage in remote mediation. We can mediate online using Zoom or other software. We have done conference call mediations over the phone, and of course, in person, using safe distances and masks upon request. We also received a USDA grant of some pandemic funds that were made available in conjunction with the Virginia Department of Agriculture to develop a program for credit counseling. The 2018 amendments also allowed us to provide credit counseling. To help in our efforts to prevent foreclosures and as permitted by the 2018 Farm Bill, we have hired an experienced and qualified individual to serve in the capacity of a credit counselor. All information discussed between the producer and the counselor will be kept confidential and will not be used should mediation become an option. For more information, please contact the Mediation Director for FARMVA, Judith Ogden, and that is her email address. Thank you for considering our program. For more information, visit our website, contact Judith, or contact me, Deborah Burke, and we'll be happy to help explain any of the options that are available, any of the questions you might have about mediation, or about the agricultural mediation program generally. Thank you for your time.